the second case, which is Hogan versus Wayne County. This is a case number 167262. This is a mini oral argument on the application, each side having 15 minutes of argument. Mr. Desi, you have, you can reserve some time for rebuttal if you'd like. We just ask you to keep track of it. And you have 2 minutes of fire-free zone, which you're able to waive if you would like. But you can proceed when you're ready.
Good morning, Your Honors, Madam Chief Justice. May it please the Court. Michael Desi, appearing on behalf of the plaintiff appellants in this case. I would like to reserve 2 minutes for rebuttal, if I may. Your Honors, we're here in a case that was filed as a putative class action on behalf of a large number of women who were formerly housed at the Wayne County Jail. The case involves claims asserted under Michigan's Elliott Larson Civil Rights Act. The Court has ordered supplemental briefing, and I will discuss those issues, but I do believe that the issues that were requested on supplemental briefing are sort of inextricably intertwined with some of plaintiff's substantive arguments about the PLRA in general. So, for instance, to discuss the issues that were asked by the Court for supplemental briefing, one of the first questions is a dismissal under the Prison Litigation Reform Act, is that dismissal with or without prejudice? That is a question in which the Court has requested supplemental briefing. I believe that question, while it is narrow, I also think it is fairly easy to answer that question. The federal courts have universally and uniformly interpreted the federal PLRA as requiring a dismissal for failing to exhaust administrative remedies as a dismissal without prejudice. I would ask that this Court find and hold the same, interpret Michigan's PLRA to also be a dismissal without prejudice if the dismissal is based on a failure to exhaust. The reasons for that are quite simple. The failure to exhaust is not jurisdictional. It is not considered jurisdictional at the federal level. That is by Supreme Court precedent. It has been uniformly accepted by all of the courts, and many courts have interpreted a dismissal under that provision as akin to an administrative requirement which a plaintiff may later satisfy. So I think that is the quick and simple answer to the question of the with or without prejudice. The other question that was asked by the Court for supplemental briefing was whether one of the particular plaintiffs, Krista Anson, was a prisoner within the meaning of the PLRA at the time that the complaint was filed. That question I also think is very easy to answer. The statute speaks directly in terms of saying a prisoner cannot file. So I think it's no more complicated than looking at the fact that the complaint in this matter was filed around 1:30 in the afternoon, and Ms. Anson was later picked up and booked into the jail at about 9:30 or 9:45.
As long as we're talking about Anson, why didn't you tell us about Anson's death?
I'm sorry?
As long as we're speaking about Anson, why didn't you tell us about Anson's death?
Well, I did file...
Doesn't that matter?
I did file a motion, Your Honor, to substitute her estate into the case.
When?
I filed it last week, and that is pending with the Court.
And was it not in response to the Court asking, is this person dead?
Yes, Your Honor, it was. Admittedly, I should have filed it sooner. I did file a similar motion in the federal action in which Ms. Anson was a plaintiff, and it was just simply by my oversight that I didn't file the motion in the state court. But I did file the motion and provided the Court with the letters of authority that were issued by the Circuit Probate Court appointing a personal representative.
And what impact does this have on the issues before us, particularly whether she's a prisoner at the time the complaint was filed?
Well, I don't think it has any bearing on that issue because her claims would still survive to her estate, and her estate could still pursue the claims. So I don't think it really makes any difference in terms of answering the question of whether she was a prisoner at the time the complaint was filed. Still, we look at the time that the complaint was filed. We looked at when she became a prisoner in the jail. She wasn't booked in the jail until almost 8 hours after the complaint was filed. So I think it's simply a matter of statutory interpretation to say she was simply not a prisoner when the complaint was, quote, filed.
One more question. Aren't you required to show that there's some lack of prejudice to the defendant when you file the substitution for the estate?
Am I required to show there's, I don't believe that there is any lack of, or I don't believe there's any prejudice considering that, one, they've had notice of her death, at least in the federal action, and two, they did take her deposition. Discovery was completed for her before she passed away. And apart from that, I don't really see the relevance or bearing on it, considering if her estate is able to survive in the claims and stand in the stead of her place as a plaintiff, I'm not really sure what the prejudice would be to them, considering the discovery was completed and the motion has been filed.
All right, I said that would be my last question, so we'll leave it to Ms. Masseron to tell us what the prejudice is.
So I think there's an open question, right, as to when she was actually taken into the custody and control of the jail. We know when the complaint was filed, we know when she was booked. Is this determinable if this were to go back? I mean, I'm sort of at a loss of why we don't have the answer to that in this case. Why we don't have dispatch records, we don't have any kind of documentation that shows when she was taken into custody and control of the jail.
Well, Your Honor, to answer that question, the only records that I have are what's been provided to me from Wayne County. And Wayne County is the one that filed her booking record with the court as an exhibit with the trial court. And that booking record shows that she was booked in at 9:45. So I don't think anybody really gave it any more thought about the actual time she would have entered the jail or if she had been in custody somehow before she was booked. I mean, I can't imagine she was at the jail for 8 hours sitting and not having been processed in, because they bring them through the door to process them in. That's the first thing they do. So the record that was provided by Wayne County shows that she was booked in at 9:45.
And that wasn't ferreted out in the deposition either?
No, it was not. It was not, Your Honor.
So now that she's passed, is there any ability to actually resolve this question if we find that the question of whether or not she's a prisoner actually depends on when she was subject to the custody or control of the jail?
Well, Wayne County does have cameras, and they use surveillance cameras in the hallway, so unless they had some sort of visual imagery of when she was literally walked into the building, I don't think that you could make any further determination other than that she wasn't booked into the jail at the time. And so if you look at the purpose of the statute, the purpose is to place certain restrictions on inmates or prisoners to complain about prison conditions, and she just simply wasn't even there. So I just don't think either the letter or the spirit of the statute would seem to apply if she's not yet in the custody. Now, the defense has made the point saying, well, maybe she was picked up in another jurisdiction and then she was brought over, and then I believe it's their position that that would still make her a prisoner. Well, this dovetails into my other arguments in the application, which is that I don't believe the PLRA should apply to any prisoner other than someone who is a prisoner of the current prison or
Counselor,
jail.
before you get to that, I'm still looking at the question of substitution of the party, and I'm looking at MCR 2.202, and under A1B, requires a filing within 91 days of notice of death. And so we received, I think, at this court, quite late notice of death, but when did the federal court receive that notice, and what's your position about whether you've complied with this court rule?
Well, I believe I complied with the court rule if there wasn't an actual notice of death filed with the court. I understand the notice of death, once that's filed with the court, that starts the clock for the 91 days, but there wasn't a notice of death filed with the court. Best of my recollection, it was filed in the federal case perhaps in June or July. I couldn't confirm that for certainty with you at the moment, but there wasn't a notice of death filed. So I guess at the time the case had been pending, the application in this case had been pending for almost a year, and we were out of the trial court. So really it was just an oversight on my part not to think to file a notice of death at that point, since we were on an application for leave that was pending. But I believe I've complied in the sense that there wasn't a notice of death filed with the court, which would have triggered a 91 days.
And if you had to show prejudice, is it just prejudice with respect to the action in this court, which I think would be maybe a lower burden, or with respect to the action if it were to return in the trial court?
The action, let me say that again, Your Honor.
In the trial court.
Well, I think it would be to the trial court, because certainly the defense is free to challenge that later and to say, if upon remand, to say, well, we don't believe the cause of action survives death. I'm not going to speak for what they would or wouldn't do, but it seems like that would be the appropriate time and place to raise that issue.
Getting back to the first question and your position that while the requirements under the PLRA need to be complied with, they don't mandate a dismissal with prejudice, and can be corrected later. And I would say, you know, there are other cases from this court that would suggest that that might be the case, right? Progress Michigan talking about a verification requirement, Otgen talking about an affidavit of merit, you know, reversing Scarcella. But what do we do with the Court of Appeals opinion, or what do you do, and are we bound by the Doe versus Department of Corrections, where it held that the plaintiffs who failed to comply with the PLRA must have their actions dismissed and cannot be given an opportunity to amend the complaint?
Well, I don't disagree that a failure to exhaust under the statute requires a dismissal, but I don't think that is a substantively distinct question than whether you can amend. The law has always been clear that failure to exhaust cannot be cured by amendment, and that is the same in the federal courts. You cannot cure a failure to exhaust in federal court by amendment. But the federal courts have also said you are free to refile if the case is dismissed and you then satisfy those procedural requirements, you're free to refile it. So I believe that that particular point made by the Court of Appeals, that if you can't amend, that does not, in my opinion, lead to the conclusion that you cannot then refile. It just simply means you cannot amend to cure the deficiency.
But in certain actions, say, like where the statute of limitations has expired, the fact that you can refile effectively means, you know, your statute has expired. It is a dismissal with prejudice. If you could amend it, then you may have a claim like we're talking about in some of these other cases.
Well, I don't know if that would always be the case. I guess there could be tolling, and Michigan law certainly recognizes that once you're filed in a case, your statute is tolled. So if you're filed in a case and eventually it's dismissed, you should be able to refile the same day, and having not lost any time on your statute, since your filing initially would have acted to toll. But like Judge Lawson, for instance, from the federal court, wrote an opinion that's cited in my supplemental brief, talking about why a dismissal for failing to exhaust is without prejudice, and he makes the point that it's an affirmative defense, and we don't simply know the factual context of how it could arrive next time around, and it would be left to the defendants to assert that defense appropriately or not, depending on whatever the factual, the procedural posture is. So it's always been the case that a dismissal for failing to exhaust is not considered jurisdictional, so therefore it can be refiled.
So the relief you're seeking is not the ability to amend your complaint to correct that. You want a dismissal without prejudice, and then whatever happens with regard to your ability to refile is a case that's not in front of us.
Yes, Your Honor, I think that's exactly what I gave that a lot of thought, and I don't think you could remand it and ask that person be reinstated. I don't think you can, because as the Court of Appeals noted, and I accept that proposition, you cannot amend to cure the failure to exhaust.
Is there a distinction between the failure to exhaust and the failure to disclose, the disclosure requirements of the PLRA?
I don't think so. I think either one of them would result in a dismissal without prejudice to a plaintiff's ability to reassert and refile the claims if and when they can meet those requirements. So for instance, in this case, a lot of these women are out. They were out of prison or jail or wherever they were incarcerated. They were out, but still within the statute of limitations time.
Could the disclosure requirement, though, be subject to amendment?
I don't think the disclosure requirement I don't think that could be subject to amendment either. I don't think those procedural requirements could be subject to amendment. I believe it would just be dismissal without prejudice and then refiled. So if I'd like to reserve the rest of my time if that's okay with. Thank you.
Sure. Thank you.
May it please the court, Mary Masseron on behalf of the Wayne County Defendants Appellees. With me at council table is co-counsel Brianna Combs. The Michigan Prison Litigation Reform Act was intended to limit the number of lawsuits a prisoner can file because of meritless lawsuits resulting in huge waste of time and money that could be better used for other needs, including meritorious prisoner lawsuits. This case exemplifies the problem that the legislature sought to address and confirms why a with prejudice dismissal was appropriate here. In answer to the court's questions, first, when the legislature mandated dismissal in 600-5507 without any qualifying language directing that it be without prejudice, and when the default Michigan rule is that an involuntary dismissal operates as an adjudication on the merits with prejudice, the result is to require an order of dismissal, which means with prejudice. Here, and even if this court disagrees and adopts plaintiff's rule, permitting a without prejudice dismissal here would be entirely inappropriate. Anson was a named plaintiff in 2 prior lawsuits that were voluntarily dismissed due to various inadequacies, and a named plaintiff in a federal lawsuit that was dismissed with prejudice because Anson and the other named plaintiffs failed to exhaust their administrative remedies, a ruling that was not appealed. That alone is enough to support with prejudice dismissal. With respect to whether Anson was a prisoner, for over 2 years, plaintiffs failed to argue in the trial court that Anson was not a prisoner, because they received the booking records in the very first filing that Wayne County made. And they focused on and chose to litigate other issues involving the grievance procedure, involving the class certification, and so forth. After plaintiffs lost on those issues, only then in the Court of Appeals did they belatedly and half-heartedly raise a question about Anson's status in the Court of Appeals. And then when the Court of Appeals didn't specifically address it, they did not file a motion for reconsideration saying, hey, that was in our brief, you forgot to decide it. They let it go. And then they filed an app for leave to this court, which was not focused on Anson's status as a prisoner or the booking records. They included a couple of paragraphs in passing in the application for leave because they chose, as is the plaintiff's right in litigation, to determine how they would pursue their claim. And requiring a party and limiting a party only to the issues they raise is a foundational rule of this state's jurisprudence and of every jurisprudence in the country that I'm aware of. Why do we have that rule? We have that rule because we want to prevent exactly what plaintiff is trying to do here, which is to spend huge amounts of time and money focusing on some issues, and then if you lose, say, oh wait, now I have some other issues I didn't bother to really raise and press them below, please help me out on appeal. That's not the way the system works. And if in any area of law, this court should be thinking about those foundational rules, it would be in this area where the legislature enacted this statute because of the enormous amount of time and money spent by the courts and the government defendants in litigating various prisoner suits. I can expand.
I read MCR 2.20A as requiring the plaintiff, when they file a motion to substitute the estate for the plaintiff, to also plead that there be no prejudice to the defendant. I don't see that in their motion, but they came today to court and said, but there is no prejudice. So I'm going to ask you, is any prejudice suffered to the defendant by allowing the substitution?
It seems to me, and I have not had time to fully think through the implications, but yes, here's a case where all the way through, Ms. Anson was a named plaintiff, brother counsel had an obligation to determine whether she was a prisoner or not before the first complaint was filed. he had an obligation to interview her. The first complaint discusses her as a prisoner and includes all of this information about her prior, some of her prior litigation. All of this goes through the trial court in this matter, and now, when she's no longer available for any discussion or investigation in terms of the timing and so forth, there is a belatedly filed substitution at the behest of this court's inquiry.
So you're basically saying because I can't depose Anson, I'll never know the answer to this question?
And Brother Counsel is talking about a deposition. I'm pretty sure I've read this whole record, but I have not read all the records of all the other repeat litigation in which Brother Counsel has engaged in the federal courts and in prior lawsuits. So I have not seen any deposition, but certainly it would have been taken a long time ago. And as he conceded in questions from the court, he didn't ask about this.
Why wouldn't that be a record in the possession or control of your client? Why wouldn't the answer to that question of when she actually was subject to custody and control be in the knowledge of your client?
I do not know for a fact whether if they pursued further investigation in some kind of remand, what they could find, because it's beyond the scope of this record. And maybe I should have asked them, but I did not. As far as this record is concerned, the only thing we know is what the county filed, which is a booking record that shows that on the date of the filing of this complaint, she was incarcerated. Now, you have those hours listed on that booking record, and I think there's a couple ways to deal with that. One of them is, would have been, had Brother Counsel not asserted she was a prisoner and not raised the issue until after the matter was done in the trial court, there would have been an opportunity, presumably, to determine did she come from another lockup, how long was she held, what happened, and so forth. None of that happened, not because of the county. None of that happened because Brother Counsel did not raise the issue, didn't pursue an investigation, and only, I guess, after the lower court ruled against, thought, oh, hey, here's a straw I can grasp at to maybe get a different outcome with respect to this person. And again, I don't believe that's the way the system should operate. It's unfair on its face because that's why we have all of our rules about finality. You have the opportunity to make your arguments. And you raise your arguments, the other side has the opportunity to do discovery and address the arguments. None of that happened here, not because of the county, not because of the defendants, but because those issues weren't raised.
Counsel, getting back to the dismissal with prejudice or without prejudice debate, why wouldn't we just follow what the federal courts do and sort of allow a dismissal without prejudice when something can be fixed with filing a new lawsuit, understanding there could be time problems and whatnot? Why wouldn't we just follow that same rule?
Well, Michigan's statute differs in language in various places. Clearly, the legislature modeled it on the federal, but did not adopt the entire federal statute. And equally important, Michigan's statute was enacted against the backdrop of Michigan law. We cited in our brief 2 other statutes where when the legislature wanted a without prejudice dismissal, the legislature specified that. And that language is absent from this Michigan statute. And our court rule also speaks about when you enter an order of dismissal without saying anything else, just this is dismissed, the default rule is that it's with prejudice. And that makes sense here, because the whole idea is not to have endless repeat efforts to get it right, but to allow for appropriate meritorious lawsuits to be brought.
Counselor, you would agree, though, that the decision for failure to exhaust isn't a decision on the merits. And in fact, the lower court explicitly stated that it wasn't a merits decision. And shouldn't that come into our thinking about whether this is a dismissal with or without prejudice?
I think a dismissal for failure to exhaust is not a decision on the merits of the actual claim, but it certainly is a substantive dismissal, unlike a dismissal for lack of jurisdiction or failure to join a party, where the court is essentially saying, we can't proceed with this, we're the wrong court, or we don't have the right parties, so we're not dealing with anything. When you deal with exhaustion or preemption or any one of a number of doctrines like that, it's a substantive decision.
And just getting back to your point about sort of, repeat litigation, and, I mean, there's a difference between dismissing with prejudice because it's harassment or, filing the same claims over and over. I mean, that's different than just a carte blanche rule that it's always dismissed with prejudice, isn't it? I mean, nothing is to say that a judge can still, even if we said, no, it's not a carte blanche rule that it's always with prejudice, there's still always the opportunity to dismiss with prejudice because of the reasons you outlined.
Certainly, we urge the rule be with prejudice based on our reading of the statute, and I think I've discussed that and it's in our briefs. If the court doesn't want to go that far, it should certainly make clear and should affirm the lower court here on the basis that this is the fourth lawsuit in which Anson was named, and that is a kind of harassment and undue expense that warrants a dismissal with prejudice. I could speak at length, but I don't want to unduly take the court's time, and I feel like I've made the key points, so perhaps I'll stop unless anyone has further questions.
Thank you.
Thank you.
Mr. Desi, you have a minute and a half of rebuttal.
Sure, I'll just be brief, Your Honors. Just to clear up some of that confusion, I know this might be a bit outside the record, but Ms. Anson had been in and out of the jail a few times. So when Sister Counsel refers to how she'd been a prisoner, she's in the jail, she may have been at times. But fortunately, Ms. Anson had gone in and out of the jail a few times. So I knew at the time that we filed the complaint that she was out of jail, but I don't know how soon after I found out that she'd been picked up and put back in jail that night, but it was after the complaint was filed. The only other thing I would note is, in terms of the court's discussion about why shouldn't it just be without prejudice, as the federal courts have said, I cited Green versus Meese in my supplemental brief, which was a Seventh Circuit case, and in analyzing that same issue, the Seventh Circuit decided, they said, well, if we look at Fed Rule 41, which is similar to our state court MCR 2.504, they analogized those rules and said, well, Fed Rule 41 says most dismissals are without prejudice, except unless they're a dismissal for lack of jurisdiction or improper venue, or as Sister Counsel points out, failure to join a party. And our MCR 2.504 essentially tracks the same, provides for the same language. So in analyzing why it should be without prejudice, if the federal courts found that to be instructive, I think that MCR 2.504 is just as instructive as what the federal courts have relied on in holding that it would be without prejudice. And I see my time is up, so unless the court has any questions for me.
Thank you.
Thank you, Your Honors.
The case will be submitted.